Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Our next case is State versus Delau. We'll hear from the appellant.
Thank you. Good afternoon, Your Honors, and may it please the court, Zachary Dunn here on behalf of the state. And with the court's permission, I'd like to reserve 5 minutes of time for rebuttal. This case is before the court based on Judge Dillon's dissenting opinion at the Court of Appeals. The dissent was based on 3 grounds: preservation, the merits of the lay opinion argument, and prejudice, each of which the state raises in this court as an independent and adequate basis for reversal. But I'd like to start, if I might, with prejudice. I know that a prejudice analysis usually goes last, but our position is the prejudice analysis is the most straightforward way for this court to dispose of the case. To be clear, we think we have winning arguments on preservation and the merits of the lay opinion testimony, and I'll be discussing those with Your Honors in just a few minutes. But I think this court could do much like it did in the Pabon case, which was released last Friday. And say that even assuming there was error and even assuming there was preservation, that the defendant had failed to demonstrate prejudice in the case. And we think the Court of Appeals prejudice analysis is significantly flawed. It focused on the significant weight the jury likely placed on Officer Carsow's testimony because it ignored this court's case law in Campbell, where it said, "It is well established that the admission of evidence without objection waives prior or subsequent objection to the admission of evidence of a similar character." And I'd like to direct Your Honors to record page 23 and 24, which is the search warrant application, which was submitted and proffered to the jury without an objection by defendant. This search warrant contained in substance, if not in exact form, the exact same testimony, the exact same information that formed the basis of the challenge testimony. And we quoted on page 18 of our brief, this comes directly from the search warrant application. I, meaning Officer Carsow, have formed an opinion satisfactory to myself that the above named person, the defendant, Mr. Delau, drove the above described vehicle on the above described highway or public vehicular area while under the influence of an impairing substance. And so that information was available to the jury, that being Officer Carsow's belief that Mr. Delau was intoxicated and was the driver of the vehicle. So even assuming there was some sort of error in Mr. Carsow's testimony at trial, that was waived under Campbell because the exact same evidence, or very much similar evidence, was introduced without objection by defendant's counsel. So simply that's our primary submission on the prejudice argument. We think the easiest way for this court to dispose of the case. But I would like to talk about our our preservation argument for just a moment. And as we mentioned in our brief, a reservation or a ruling on the preservation issue is not the state's preferred resolution because it would require a remand to the Court of Appeals to determine the plain error issue that was raised below but not ruled on by the Court of Appeals because of the way that they disposed of the case. But this court is well aware under Appellate Rule 10, the way preservation works. A party must state the specific grounds for the ruling the party desired the court to make if it is not apparent from the context. As we can see on page 206 of the transcript, there was no specific grounds for which the objection was made in this instance. So the only question really is whether the specific grounds were apparent from the context. And we believe that the dissenting opinion does a very good job explaining why exactly it was not apparent from the context. There could have been many grounds that defendant's counsel could have been grounding his objection in, such as a lack of foundation, a lack of relevance, or whether the testimony was duplicative, because much of the same information was already stated by Officer Carsow on page 196 through 198 of the record. So the fact that the objection could have been on one of many grounds means that the basis for the objection was not apparent from the context. But from what's available to the court in the record here, is some indication that it is unlikely that the objection was on lay opinion grounds, because the issue of lay opinion testimony was never raised at trial, and in fact, the term lay opinion does not appear in the transcript at all. So, the likeliness that an objection, which did not state the grounds for the objection, but was on a topic that was never raised or discussed in the trial court, is in our submission unlikely, which means that it's not apparent from the context, Your Honors.
Is it your position then that an appellate court is not empowered to, in looking at the testimony or even the entire record, base its determination on its evaluation of evidence where there was a general objection lodged, but cannot determine on a specific ground that there were grounds to uphold the objection?
Well, I think that an appellate court can, but it depends on what is raised by the defendant in the case. Here, there was a general objection, and in the Court of Appeals in this court, the only argument is that the objection should have been sustained because of the presence of lay opinion testimony. And so, if there's only a general objection, the defendant does not get the benefit of being able to argue any number of possible, ways that the trial court could have erred because, it's lack of relevance or some other ground. If it's not apparent from the context that in this case the objection was lay opinion testimony, then it's simply not preserved under Appellate Rule 10. So that would be our position, Your Honor. I hope that answers your question.
It does, but just a little deeper, if you don't mind. Is that because the defendant has waived any opportunity to have the appellate court to review it because the defendant or any party that just lodges a general objection was not more specific?
I think that's right, Your Honor. There's nothing that stopped defendant's counsel from stating the ground for the objection. And then on appeal, the only argument made by defendant's counsel was that this was lay opinion testimony. So any other argument, relevancy or it shouldn't have come in under the rules of evidence, those are waived under the appellate rules for failure to make that argument to the Court of Appeals or this court. So that would be our submission on that, Your Honor. I would like to turn, if I might, to the argument or the merits of the lay opinion testimony argument. This court said in Davis that shorthand statements of fact or instantaneous conclusions of the mind are treated by appellate courts as fact rather than opinion. And so Officer Carsow's general impressions of the scene when he arrived on scene that night, of course, are treated as fact and not as lay opinion testimony. So his description of the scene, Officer Carsow's notation of how far away Mr. Delau was from the moped, all those sorts of things are not lay opinion testimony. So the only thing that could be lay opinion testimony is his conclusion, his statement that he believed that Mr. Delau was the driver of the vehicle. But the context and the way that this officer testified is important in this case because it significantly differentiates it between the Court of Appeals cases relied on by the majority, which are Moretti and Denton. Of course, not binding on Your Honors, but we're not asking this court to overrule or say anything about those cases. The key factual distinction between those cases and here is that in those cases, the officers were specifically asked whether or not they believed the defendants in those cases were either the driver of the relevant vehicle or were otherwise at fault in the wreck that had occurred. And here, there was absolutely no testimony by officer, or there was no questions, excuse me, asked of Mr. Carsow, Officer Carsow, about whether he believed that Mr. Delau was the driver of the vehicle. Instead, he was simply asked.
Mr. Dunn, the specific question that the prosecutor asked was something like, quote, "What circumstantial evidence did you believe you had at that time that he was in fact the driver of the moped?" I mean, that's the question, isn't it?
It is, but you know, in context, we think that he was not directly asked whether he believed that that Mr. Delau was the driver of the vehicle. Rather, he was explaining.
Doesn't that question assume that he believed that the defendant was the driver?
That's certainly true, but there was no objection to the question itself.
That's a different subject than whether an attempt was made to elicit a lay opinion as to who was driving, isn't it?
I'm sorry, Your Honor. Could you say that again?
Whether whether there was an objection doesn't have any bearing on whether the question itself sought to elicit an opinion from the officer as to whether the defendant was driving or operating the moped, does it?
That's certainly true, Your Honor. The distinction that we're trying to draw is in those two cases, Moretti and Denton, the officer, right at the end of their testimony, they were asked, do you believe that either the driver was at fault or was the driver of the vehicle? And here, the testimony and the question was really, what circumstantial evidence did you have at the time to believe that you had probable cause to go and get this warrant? So there is.
The question itself was what caused you to believe he was driving, right?
That's correct, yes.
How is there any meaningful difference between that question and the question that was held inappropriate in Moretti and Denton?
Well, Your Honor, our submission would just be that because the steps taken by an officer during their investigation are relevant topics to discuss during direct examination. And so this was simply one of the steps taken, and the officer was asked, what he believed, gave him probable cause to go ahead and go get this warrant. And so the distinction we're drawing there is simply that is different than simply straight up asking an officer on the stand whether or not they believed, in their opinion, that the driver was the defendant in those cases. Of course, if Your Honors don't take that point, we would fall back both on the preservation and on the prejudice prong because the exact same information was contained in the warrant. Unless there are further questions from the court, I'd just like to take a moment to.
I would like to ask you one further question about your prejudice argument, and in particular, the document that you point us to. Do we know from the transcript? Is it in the record that that was published to the jury, or did it go back to the jury with the jury in the jury room?
We do, Your Honor. I believe it's on transcript page 206. It's right around 206 or 207. That's when defendant's counsel was asked if he had any objection, and then there is a notation in the record, and I'm sorry if I'm incorrect, but I believe there's a notation in the record that the search warrant itself was passed out to the jurors, and they looked at the documents. I'm not sure if it was brought back to the jury room itself, but they definitely had, I think, the search warrant itself before them. And I would note also the cross-examination testimony of Mr. Delau's counsel, in which they go into great depth about the search warrant application and specifically, some boxes that were on the form, box 2A versus 2B, defense counsel and Officer Carsau talked about how Officer Carsau didn't specifically see Mr. Delau driving, those sorts of things. And so, the issues in the search warrant application and what's contained in the search warrant application, we think was definitely before the jury, Your Honor.
Thank you.
Thank you. Unless there are any, I'm sorry?
I was just going to say, thank you, counsel.
Oh, thank you. We would just urge the court to reverse the decision of the Court of Appeals. Thank you.
Thank you, counsel. We'll hear from the appellee.
May it please the court, Joseph Lattimore on behalf of Robert Wayne Delau. It is well established that the jury is charged with determining what inferences and conclusions are to be drawn from the evidence. A lay witness invades the province of the jury in giving his inferences and conclusions when the jury is as well qualified as the witness to draw those same conclusions and inferences from the facts. There is a rather large body of case law that I've cited in my brief that applies that particular well-established principle to car accident cases. Everything from the McGinnis case, an opinion issued by this court, where this court held that it was not competent evidence for the officer to declare in his sworn statement that an individual named McGee was driving the Mercury vehicle because it was a statement of a guess or opinion or conclusion resulting from his investigation. We also have a more recent opinion in Denton, where the investigating trooper improperly testified that he believed the defendant was driving at the time of the crash because the, quote, seating position was pushed back to a position where I did not feel that Miss Mitchell would be able to operate that vehicle or reach the pedals. So we have a well-established track of cases that hold that this sort of an inference or conclusion drawn in these cases where an officer is on the scene after an accident and gives his analysis from after the fact observations is impermissible. And that's precisely what occurred in this particular case. Officer Carsau impermissibly invaded the province of the jury by drawing inferences from the evidence to convey his opinion that Mr. Delau drove the moped. Now, the state and the dissent focus too much on the purpose of the question in an effort to show that this was not opinion testimony at all. But it doesn't matter that Officer Carsau was not specifically asked by the prosecutor to give a formal opinion. The state tries to distinguish Moridi and Denton by arguing that law enforcement officers were explicitly asked in those cases for their opinion, and that's what makes those examples of impermissible lay opinion testimony. But a careful reading of Moridi and Denton does not reveal exactly what the exchange was between the prosecutor and the witness when they gave the improper lay opinion testimony. The opinions do not contain the prosecutor's precise questions. So in this case, it's accurate that Officer Carsau was asked to provide the circumstantial evidence that he had gathered as he applied for the search warrant. And so the question had some relevance to giving the jury an explanation as to the officer's investigation in the case. But the answer to that question went far beyond what the prosecutor asked. The state.
How do we divorce the two? How do we divorce the two, separating the improper lay opinion on one hand, improper as ultimately was found by the Court of Appeals at least. How do we find that that was improper? Keep that separate from how he operated as an officer in giving the information as he knew it, as you just said, to get the search warrant.
Well, it's certainly it's certainly proper under a number of cases in North Carolina that an officer can give the jury some background information about the investigation, and even go so far as to explain what was done in terms of applying for a search warrant. But what crosses the line here and invades the province of the jury is his explanation of how he arrived at the conclusion that Mr. Delau was the driver. The state's wrong when it contends that Officer Carzow just gave the facts and circumstances, including, quote, defendant's injuries, defendant's ownership of the moped, defendant's proximity to the moped, and the short period of time between when 911 was called and when EMS arrived.
But he is entitled to state those things as facts, isn't he?
He is. But
so the only thing that, in your view, is inadmissible, at least as I understand your brief, is the opinion. In essence, the officer thought the defendant was driving.
That's correct, Your Honor. And I think
that's the only thing in your argument that would be inadmissible.
Yes,
right?
It's
Okay.
the latter part of his answer where he states the fact that the extent of his injuries told me I didn't believe anybody else could have been on scene, and the speed at which both EMS and officers arrived on the scene, which I believe prohibited, too much time passing where other individuals are coming in and out. So what you have there at the tail end of his response are deductions from the evidence that he could properly give to the jury in the earlier part.
Well,
He's giving you his
Mr. Lattimore, isn't it?
Yes,
If
Your
you
Honor.
read the answer that ultimately led to the objection, it seems that the answer that's given assumes that the assumes the officer's opinion that the defendant was driving. I mean, it assumes that from the moment the answer begins, doesn't it?
It does, but
Well,
I
then
think
why shouldn't an objection have been lodged at the time of the question rather than through near paragraph of fairly clearly argumentative testimony that's explaining why the officer believes that the defendant was operating a moped.
Well, Your Honor, you can see why the question itself did not draw an objection, because although it's inartfully worded, it seems to be somewhat connected to a discussion of the search warrant application process and therefore to the investigation. So,
Well, at a minimum, though, when you get information that's subject to multiple uses, isn't the appropriate thing for trial counsel to do to object and to request a limiting instruction that the information that's being recited not be considered for the truth of the matter asserted?
well, I'm not sure that the beginning of that, I'm not sure that the question in the beginning of the response would have warranted that objection. I can see why counsel didn't do anything at that point, because it is tangentially related to the search warrant process, the investigation in the case. It's inartfully worded for sure, and
because it looks to me, Mr. Lattimore, is assuming that this objection is sufficiently specific to satisfy the requirements of Rule 10A1, then there's a number of statements that were admitted without objection at all, and that we didn't get an objection until we got to the point in which the officer was discussing the speed at which the law enforcement officers and the EMS personnel got to the scene.
well, Your Honor, I think this builds on a point that the state makes. They rely heavily on the fact that the warrant application was eventually admitted into evidence and that counsel cross-examined Officer Karzau regarding his application. But this was part of an effort to undermine the improperly admitted opinion that she had objected to previously.
I'm sorry, are you talking about the cross-examination then?
I am.
Okay, all right, thank you.
She's showing that the thought process, which he improperly had expressed prior, was not in the warrant application. She thoroughly cross-examined him on that particular point. And you can see that at pages 220 to 221 of the transcript in this case, where she ends this line of cross-examination with, there's an area where there's like room, that the facts kind of indication there may be some information there, correct? That's correct. And this is blank, correct? Yes. And you didn't write any of the observations that you have testified to when you went to go get this warrant, correct? Answer, that's correct. And the state relies on Campbell to argue that by doing that particular cross-examination, that we have waived the prior objection to the improperly admitted lay opinion testimony. But in the Wells case that I have cited in my brief, there is a particular passage that says one does not waive an objection otherwise sound and seasonably made by attempting to explain or destroy the probative value of the evidence on cross-examination. And it cites a number of older decisions from this court. So the principle seems to be...
What about the admission of the search warrant affidavit? I mean, if you look at page, I think it's 207 of the transcript, the search warrant application is admitted explicitly without objection. And the transcript says, whereupon the document was received in evidence that states Exhibit 2, copies passed to the jurors reading.
Yes. And
I mean, that's pretty clearly the admission of, the search warrant application's got a box on it that's checked where the officer says, I believe the defendant was driving, doesn't it?
It does. It does contain that information. And this
why
is again.
Why is that not the admission? Why is that not the admission of evidence, of the same or similar evidence sufficient to support a finding of non-prejudice, assuming that we were to agree with you that the evidence in question was inadmissible?
And our position is that the information contained in the search warrant application is not the same as that.
How is it not the same, given your prior concession that the facts upon which the officer relied, the evidence of those observations would be admissible and was not subject to the objection that was made?
Our position is that the inferences are not included in the search warrant application. The thought process is not included in the search warrant application. He simply checks a box that says, I think he was the driver, but he doesn't lay it out the same way that he does in his explanation to the jury at page 206. Believing that Mr. Delau was the driver was obvious from the fact that he was charged. That law enforcement believed that they got the right guy is something that's at play in every case. But the thought process is different from the bare conclusion in terms of prejudice. Because in this particular case, his thought process does undercut the testimony of the two defense witnesses in this case. He's specifically telling the jury at page 206 why you can't believe the testimony of anybody who's going to say that there was another driver, because the speed at which both EMS and officers arrived on the scene prohibited someone that could have driven leaving the scene. So that's why there's particular prejudice in this case from the admission of the inadmissible opinion at page 206. And in the end, the majority conducted the proper prejudice analysis in this case that focused on the effect that the evidence would have had on this jury. First, the opinion was from an officer, and an officer, it's been recognized, gives an opinion that carries more weight than a typical witness. And also, the majority focused on the fact that the opinion went to the contested issue in this case, the controverted issue in this case from the testimony that was presented by two defense witnesses. It went to the live issue in this case. And for those reasons, the majority correctly concluded that this was significant evidence in this case that would have affected the jury's analysis. And Mr. Delau should be awarded a new trial as a result of that prejudice that his defense suffered in this case. So if there aren't any other questions, I would rest on my brief.
Thank you, counsel. Rebuttal.
Yes, Your Honor, and may it please the court, just very briefly, I'd like to end where I started, which is a quick discussion of prejudice. Mr. Lattimore said or conceded that the only improper testimony was, I thought the defendant was the driver. That is the alleged lay opinion testimony in this case. And as you can see in page 18 of our brief, but also on page 23 and 24 of the record, that was available to the jury through other sources, namely the search warrant application, which states, I, Officer Carsow, have formed an opinion satisfactory to myself that Mr. Delau was the driver of the vehicle. So we certainly believe we have winning arguments on all three issues, but we think that that is the easiest way for this case to this court to dispose of this case by simply holding that due to the admission of the search warrant application, there could not have been prejudice based on the alleged lay opinion testimony. And unless there's any questions, I would ask the court to reverse.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning. God save the state and this honorable court.